Okay, we're back on the record in cause number 323886. Case is style of state of Texas versus John Scott Washington Jr. Mr. John Scott Washington Jr., would you please raise your right hand? Mr. Washington, you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Now, Mr. Washington, prior to us going into a break, the district attorney's office requested that you take a drug test. Could you show that to him? Okay, so there's some results that
I'm not. I wasn't aware that whenever.
well, let me do this here, Okay, now, Mr. John Scott Washington Jr., you have a right against self-incrimination. Anything that you say can and will be used against you in a court of law. Obviously, and you fill out yeah, you have a right to have an attorney, and I think that you filled out a form that stated that you was going to hire your own attorney. Is that correct?
Yes,
All right. Now, may I have that test back? Now, you are currently, we have a motion to revoke probation, so it's obvious that you were currently on adjudicated probation. Now, Mr. State, you have any, well, first of all, have you had an opportunity to see
Yes, Your Honor,
the
I have.
test results? You, and did the probation department have any recommendations regarding Mr. Washington?
Your Honor, my computer quit cooperating a minute ago, but
Wow,
I'm getting it back.
Okay.
And in looking over Mr. Washington's case, it appears that he has been almost non-participatory in probation. He has also in the past tested positive.
I mean, the court see those allegations in the motion to revoke. We're not here on a motion to revoke probation hearing. But that will, he has a right to have a hearing. That hearing will be held at some later date, not today. And plus, Mr. Washington has a right. He said he'd like to hire an attorney. So, but you are currently on probation, and so
I'll go about knowing when I go see, because when they called me, they told me that I have a warrant for my arrest. That's all I knew, and they never gave me the date to go see.
okay. Well, Mr. Minor. Now, see here, we say he admitted to ecstasy use. Is that correct?
Yes.
How long does that? Do you have an idea how long that stay in the system? Do we know anything about that? This drug?
7 to 10 days.
And
7 to 10 days.
7 to 10.
And my professional experience, I'll stress it that way, is that with the ecstasy that's on the street today, there's a lot of methamphetamine that's laced in with it to give it a little extra kick. And so that's would be indicative of why it's the methamphetamine, and which is all the more reason why illicit drugs are dangerous, because you don't know what
I see.
you have.
Okay, I see what you're saying. So that's why that came up, possibly. Okay. You may see his terms and condition of his probation. Has he now with these allegations of testing positive. Has he had any drug treatment while on probation? Do we know anything about that?
No, sir, he hasn't. He hasn't, looks like he transferred to Orange County and did not report, to Orange County. Well, he last reported to Orange County.
Okay, so this case was, he was supposed to be supervised in Orange County. Is that correct?
Yes, sir, as a courtesy, yes, sir.
As a courtesy supervision? Okay, but you're saying that, okay.
Courtesy, he did not report.
Oh, this is the motion. I was looking for the, his,
The order.
yeah, when he was, his probation order, right? And then we still have it was, from 2019. Okay. So basically, Mr. Minor, the Jefferson County office just never had any supervision over him. He was supposed to be, the supervision was transferred to Orange.
Yes, sir. He was supposed to be reporting by mail and or online, but he never reported,
Okay.
to the probation department, either by mail or online.
Let's see,
May I say
Lieutenant,
something?
hold on a minute. Yeah. Mr. Shearer, did I ask you whether or not you had any recommendations?
Yes, Your Honor, you did. And at this point, the state would like to move forward with revoking his probation because of the circumstances in the MTRP.
Okay,
So I think we would probably need to schedule a hearing. if he's
Okay.
not willing to admit to it.
but what I need to do, let me give some bond conditions. Which mean you're not out on bond?
No,
He's on probation.
But they filed a motion to, okay, they filed a motion to revoke your probation, right? And so you had to bond out of jail on that.
yeah, but once I came to court, I was not on bond anymore. That's what I understood.
When was the last time you were, last time you bonded out?
Whenever I got taken to jail for it, February of 2019.
You haven't been arrested, so you was arrested on February
Oh, no,
2019?
Okay, they gave me a personal release bond. I was arrested and I was in jail for 8 days for this.
So he's on a PR bond, so you're on a PR
A week-
bond.
Yeah, a week in Orange County, and I did a little over. a
Okay,
year.
let me give me some bond conditions. Okay. This is what we're gonna do. Six. John. Washington. Junior. do we have the one that have the lines in there that, where I can write in? Let me see. It should have one where they have like AA meetings and that type stuff.
For the bond solution?
Yeah, let me see it. Let me see that, in that folder?
This one?
Right.
Okay, I'm gonna have to go make some copies.
Let me see. Hold on a minute. No, okay, we're gonna have to get another cover for, oh, it's front and back.
Mhm.
Yeah, I'm gonna need this one. Mr. Minor, in reference to Ozar, the local drug and alcohol council, what I was thinking as a condition of bond is have him to get a screening and, whatever recommendations that they make as a condition of bond that he would have to follow. If it's outpatient or inpatient treatment, that would be, a recommendation. I'm just, wondering if it's possible for, someone at the probation office to make contact with Ozar, because I think it has to be, a screening has to be set up. Is that correct?
Yes, sir.
Okay.
I will give those officers.
Okay, and so what we're gonna do is, we're gonna get a screening to give us an idea of, they'll give us an idea of what type of treatment he needs. Okay, now this is just as a condition you bond.
Okay,
Yeah, you're still on probation and
yes,
stuff.
sir.
Um,
So would I just call the probation office and talk to them about if I have a
Well,
visit?
Mr., you'll be able to talk to Mr. Minor today.
Okay.
Okay? Now, I'm gonna give you some bond conditions.
Yes, sir.
And, oh, I should have filled it out and had you to,
Copy.
yeah. I just thought about that, John Washington.
Your Honor, it's been brought to my attention, he can do his substance abuse assessment at the probation department.
Oh, you can? Okay, okay. 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 So he's gonna have a, is that the condition in his probation order that reads submit to alcohol and drug screening at the direction of the Jefferson County Supervision and Correction Department or supervising jurisdiction and pay any associate fees? Is that the one?
That's the drug testing.
You can write it in, Judge, we'll take care of it.
Okay.
Just submit to substance abuse assessment.
Okay. This front and back, just make a one copy there. Thanks. Yes. That goes in that blue folder. That's the test results. Okay, thank you. Okay, Mr. Washington, what you just been handed the standard bond conditions and County Court Law number 2. I will go over these bond conditions with you. And it reads, following the arrest and or accusation in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or others subject to the following additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. And that's pursuant to Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that?
Yes, sir.
And number 4, that doesn't apply. That only applies in DWI cases. Your case is not a DWI case. So we go to number 5. Number 5 states that submit to, she didn't copy the back
Oh,
page.
okay. I didn't know it was written down.
Huh?
I didn't know it was written down.
Yeah. Okay, number 5 reads, submit to substance abuse assessment at the Jefferson County Community Supervision and Corrections Department, which is the probation office.
Yes, sir.
And number 6, attend AANA meetings 2 times a week and provide proof to the court.
Yes, sir.
Okay, so you're gonna have to get in an AANA program. They're gonna give you paperwork to fill out when you come to court. You need to bring that paperwork every time you come to verify that you have been attending.
Yes, sir.
Now, your failure to adhere to the conditions of the bond may result in your bond being revoked. If your bond is revoked, they could issue a warrant for your arrest. You could be arrested and you could be placed in the county jail. Do you understand?
Yes, sir.
Okay, now, Ms. Smith, could you give him a reset? His case is being reset for him to hire an attorney. Oh, you already have it? Okay. So you was given a copy of your reset. Now, you have your reset, your bond conditions. You'll be free to go and you have a blessed day. You can, if you need to talk to Mr. Minor, you can talk to Mr. Minor. Do we have, We're on the record in two cases. First case is cause number 322328. Second case is cause number 326343. Both cases are styled the state of Texas versus Jeremy Russell Moore. Mr. Moore, is that your full name?
Yes, sir.
Mr. Moore, would you please raise your right hand? Mr. Moore, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Moore?
I'm okay.
That's good. Mr. Moore, you're here represented by your attorney, Mr. Ben Pierce. Attorney Pierce, how are you doing?
I'm doing great, Your Honor.
That's good. Mr. Moore, I have before me a motion to revoke your probation. This motion alleged that on November 6th of 2019, that you were found guilty for the offense of possession of a controlled substance penalty group 2A. And your punishment was set for a term of 180 days in the Jefferson County Jail, a fine of $400. And in accordance with the provisions of Article 4212 of the Code of Criminal Procedure of the state of Texas, said confinement was probated for a period of 1 year. On June 10th of 2020, the state filed the motion to revoke your probation. In this motion, there are 7 allegations. And I see here on the plea papers, he's pleading to 2 allegations,
That's correct, 5 and 6.
5 and 6.
Yes, Your Honor.
And so the state you're abandoning in counts 1, 2, 3, 4, and 7. Is that correct?
That is correct, Your Honor.
All right. Now, Mr. Moore,
Yes, sir.
the state is abandoning counts 1, 2, 3, 4, and 7. So they're proceeding on counts 5 and 6. Count 5 in this motion alleges that you failed to perform community service hours as required or as ordered by the court in violation of condition 14 of the probation order. Is that of your probation, or is that true or not true?
Yes, sir, it's true.
Allegation 6 alleges that you failed to report by mail for the months of December 2019, January, February, March, April of 2020, in violation of the special amendment dated November 19, 2020 of the defendant's probation order. Is that true or not true?
True.
Mr. Moore, are you pleading true to allegations 5 and 6 freely and voluntarily?
Yes, sir.
And are you pleading true because they are true?
Yes, sir.
Okay. Mr. Moore, I have before me a document that is titled Misdemeanor Plea Admonishments. Mr. Moore, it's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Moore, there's a set of initials JM on a line next to a box that's checked MTRP, true to allegations 5 and 6, and I think these are your attorney's initials BP. Is that correct?
Yes, sir.
Are these your initials
Yes, sir.
on this document, page 2? And on page 3 of the same document, Mr. Moore, there's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And on the next document, Mr. Moore, this document is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Moore, do you recognize this document?
Yes, sir.
Is that your signature above the line that says defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you are waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, Mr. Moore, prior to signing and initialing these documents, Did your attorney, Mr. Pierce, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And did you understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor, we would.
Without objection, Your Honor.
Okay, no objection. State's Exhibit number 1 will be admitted. Mr. Pierce, you have advised and counseled. Let me do this here. Mr. Pierce. Now, Mr. Pierce, you are standing in for Mr. Moore's attorney, Mr. Dustin Nayland, is that correct?
That's correct, Your Honor.
All right. Now, I should have asked that. Mr. Moore, do you have any objections to Mr. Pierce standing in for Mr. Dustin Nayland?
No, sir.
Okay. Now, Mr. Pierce, you have advised and counseled Mr. Moore. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Moore, now your attorney is Mr. Dustin Pierce. Has Mr. Dustin Pierce?
Dustin Nayland, Ben Pierce, sorry, Your Honor.
Oh, excuse me. I'm mixing the names up. Your attorney is Mr. Dustin Nayland. Has Mr. Dustin Nayland, are you satisfied with Mr. Dustin Nayland's representation?
Yes, sir.
Has he provided full, effective, and competent representation?
Yes, sir.
Now, as reference to Mr. Ben Pierce, are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
All right. Now, Mr. Moore, I will accept your pleas are true to allegations 5 and 6. I will find that you are mentally competent to stand trial. I will also find that your pleas are true and waivers are freely and voluntarily given. I will also find that there is sufficient evidence to revoke your probation, and your probation is hereby revoked. State, do we have a plea bargain agreement?
Yes, Your Honor, we do.
And what is that agreement?
The agreement is for Mr. Moore to spend 20 days in the Jefferson County Jail, of which he has already done, so he'll receive credit for time served.
And on tax and retire any fines and court costs?
Yes, Your Honor, and also that's, we will be dismissing cause number 326343. I would also like to note that he does have 2 pending felonies, so.
Okay. Now, Mr. Moore, in cause number 322328, the state is offering that you serve 20 days in the Jefferson County Jail. However, you've already served 20 days in the Jefferson County Jail. Therefore, you'll be given credit for time served. Now, the court cost in this case is $67, but you will not have to pay the $67 court cost because the time that you spent in jail has already paid it off. Therefore, the court cost is going to be taxed and retired. Cause number 326343 will be dismissed. Mr. Moore, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir. Absolutely.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Moore, I will follow the plea bargain agreement that you have entered into with the state. Mr. Moore, I'm signing the dismissal, and you'll be able to get a copy of the dismissal and judgment in just a few minutes. Just stand on the X next to where your attorney is standing, and you're going to follow the directions of our court clerk. And Mr. Moore, This will conclude your cases. You'll be free to go. You have a blessed day.
Thank you, Mr. Holmes.
You're welcome.
Thank you, Your Honor. May I be excused?
Yes, you may be excused, Mr. Pierce.
Thank you, Judge.
You don't need him to sign. Okay.
Can I get your right thumb, Frank? Take it up, it didn't take. Try it again.
Your Honor, if we may, we have numerous people in the courtroom that are waiting on the hearing for Sarah Sales.
Okay.
And the state has reason to believe that she has left. So if we could call her,
Ms. Sales?
yes.
You're welcome. Here you go.
Oh, okay. Would you, okay, we're on the record in cause number 321-328. The case is styled the state of Texas versus Sarah Ann Sales.
She was here earlier, Your Honor.
I know, I have her checked in.
Okay. You're welcome.
No response, Your Honor.
Okay. In cause number 321-328, the case is styled state of Texas versus Sarah. Hold on a minute. Sarah Ann Sales. Ms. Sales was scheduled to be in court this morning for the court's motion to revoke probation docket. Actually, her hearing was set at 10 a.m. The court's bailiff called her name, I guess, at or about 10 a.m. Ms. Sales did answer. In fact, I think Ms. Sales came into the courtroom. And as a matter of fact, we had her attorney, Mr. Wright Kimmler, also, he was appearing via Zoom at the time that we called Ms. Sales' case. The bailiff, this case actually is scheduled for motion to revoke hearing, which was scheduled at 10 a.m. And the bailiff just called Ms. Sales' name again at the courthouse door. The time now is 11:36 a.m. on today's date of May 20, 2021. Ms. Sales did not answer. Therefore, her bond will be forfeited. Warrant shall be issued for her arrest. Okay. And this will conclude the calling of the case of Sarah Ann Sales, cause number 321-328.